Yes.
There's three things arising from this morning. First, the whole legal team, particularly one member of it, is very anxious to get electronic copies of the authorities to the court. They are on their way.
Good.
We're told that because it's under 10 megabyte, an email will be acceptable to the registry. So
Yep.
that will hopefully occur this afternoon. Secondly, in answer to my Lord Wilson's point, my learned friends are happy for me to indicate that at the relevant time, Section 79 of the Nationality, Immigration and Asylum Act 2002 provided, and we can hand out copies later on if that's going to be useful, but 79.1 said a deportation order may not be made in respect of a person while an appeal under Section 82.1 against the decision to make the order A could be brought, ignoring any possibility of an appeal out of time with permission, or B is pending.
Well, that's the answer to that.
Which is the answer.
Speaking for myself, I don't think we need a copy of it.
Thank you.
Thank you very much.
Third thing, just
Sorry, can I was hoping to have a copy on. If I'm not getting a copy, I'll note it down again.
I'm so sorry.
we need very
Send
easy.
Lord Khan with a copy.
Send me a copy. Thanks.
We'll do. Digital and electronic, or
Do it in
digital and
electronic
paper,
form, or he knows
paper
how to
only.
do that.
The third thing is, without rehashing the ground, on the issue of whether the 2004 order provides a complete and self-contained code, just draw attention to section 72.9 and 10, which we looked at in connection with the tribunal decision. Those are the provisions that restrict the tribunal to only looking within the four corners of the order.
Sorry, could you give me that again?
That's 72, subsection 9 and subsection 10. We
Just give us the MS number again, please.
and the MS number would be 384.
Yes.
So, at last, Draga, volume 2 of the authorities, behind tab 23.
Just before you leave 9 and 10, I've been puzzling over 9 and 10, 10 in particular.
Oh, right. Sorry, I'll get that back.
That's dealing with if they agree with the Secretary of State, if the presumptions are not rebutted. But that's all.
10 tells the tribunal that it has to start off by considering the certificate.
Yeah. And then decide whether whether the presumptions are rebutted or not. I think you can read
Yes.
B as.
Well, I think they have to decide, first of all, whether the presumptions apply.
Yeah.
Yes, first
Yeah,
of all.
whether they apply. Yeah.
And then,
I think I was reading that as wrapping up the question
Yeah,
of.
I think that's right.
Yeah, they haven't been rebutted. But this is where they're deciding against, where it's all covered by the presumptions. It doesn't tell us what happens in a situation in which
they don't
it doesn't tell us whether, either what happens when they don't agree or whether there is any ground which is covered which hasn't come within those presumptions.
Well, let me just put the opposite point of view to my lady, that it does tell us
Okay.
by implication.
Okay, I that's another way of looking at
Yes.
it. But it's not entirely determinative on its words, is it, if anything?
No, I just say it's a pointer.
Yeah.
So Draga, volume 2, 23, I'm sure the court will have pored over this, so I'll take fairly speedily the question of what does Draga mean? And what we say is that between paras 54 at MS 1004 and para 58 MS 1005.
Was it never reported, this case? Seems surprising. I remember when I was in the family division, I asked Mrs. Bryn Davis, the law reporter, this is such an important case, why haven't you reported it? She said, because I don't agree with it.
As the editor of a set of law reports, that's quite an interesting approach.
Anyway,
Bear
sorry.
that in mind in the future.
I mean, the trouble in the immigration field, an awful lot of quite important decisions which don't get reported because there's so many of them.
That's right. And there will be an awful lot of decisions that didn't get reported if the yardstick was whether the editor agreed with it or not.
I'm sorry.
Perhaps none of them
Where
will
were
ever
we?
be reported. I don't know.
Which paragraph?
Well, 54 to 58, MS 1004 to MS 1005, 58 up until the 1, 2, 3, the fourth line down, up to the word but. Our analysis of these paragraphs is that the court proceeded on the basis that there was an unlawful deportation decision and that it did bear on and was relevant to the decision to detain in the Lumber and Kambadzi sense. But, and then one gets to the word but in para 58, for the reasons from 58 onwards, to treat that error as undermining the decision to detain would be inconsistent with the operation of the statutory scheme and the principle of legal certainty. In fact, Lord Justice Sullivan puts it slightly higher than that, doesn't he? He says at para 62 that it would frustrate the operation of the statutory scheme if the Secretary of State wasn't able to rely on the tribunal's decision. And then 65, it would frustrate the operation of the statutory scheme if the Secretary of State wasn't able to rely on the fact that no appeal had been brought. And then he adds legal certainty into the mix at para 67. And without giving the court the references, unless asked to, our analysis of how Draga approached the case is the same as the analysis of all the courts who've looked at that particular matter. So, just before approaching the fundamental principles that we say this approach is in conflict with, I just wanted to say something to start off with about the premise of what Lord Justice Sullivan is saying on behalf of the court here, the premise that it would frustrate the operation of the statutory scheme if someone was able to assert later on in false imprisonment proceedings that the deportation decisions affecting them were unlawful and tainted the decisions to detain them. So in my submission, there are three reasons why that premise is flawed and is certainly overstated. First is very simple. We say that the purpose of the statutory appeal provisions is to enable somebody subject to the deportation process to appeal to an independent tribunal who will decide whether that person can lawfully and ought to be deported. That purpose doesn't include the tribunal deciding whether the person can or should be detained. Parliament could have legislated to provide appeal rights in relation to detention, but didn't. Second, Parliament did not intend that a deportation appeal was to be finally conclusive as to whether it was lawful and appropriate to deport a person. That's not the purpose of a deportation appeal, and that's not how immigration law works. And I draw attention here to 2 points. The first is the way the respondents very carefully put the case on this at MS 103 in their printed case at 7.32. They say adherence to the rule of law must include respect for extant court decisions.
Sorry, which page?
MS 103.
Thank you.
So this is their case, 7.32. Adherence to the rule of law must include respect for extant court decisions. If the ultimate outcome of a particular appeal is that a tribunal court rules that a decision to deport is unlawful, it could not be open to the Secretary of State to proceed with other action against the individual, and this is the careful bit, on the simple basis that the tribunal or court was wrong, unless and until the legal system reverses the basis of the ruling that the decision to deport was unlawful, the Secretary of State is obliged to respect that. This is a careful wording, because one immediately thinks, well, isn't that the mirror image of what happened in this case? Isn't what happened in this case that the legal system, in Serbia, reversed the basis of the ruling that the decision to deport was unlawful? And so this prompted us to look into this issue in a little bit more detail, and we came up with the case of MA Pakistan, which was decided very recently, and it's in the additional material at tab 4. And can I draw attention, if my lords and my lady have it, to paragraphs 5 and 6 which basically show that the appellant was subject to a deportation process and he appealed, and that failed, and then he asked for the deportation order to be revoked, and that succeeded. And then what happened, you can see from 9 to 11, is that he was given 6 months discretionary leave to remain, which I am told is what happens if your deportation appeal succeeds. So you're on probation, as it were. And then he was later told that the respondent was going to start the deportation process all over again. And as you'll see very soon, the reason for that was that there had been a change in the law. And the change in the law was Part 5, capital A, of the Nationality, Immigration, and Asylum Act 2002, which most members of this court have had to deal with recently. And so MA claimed that this was all unfair and contrary to the fact that he had won his revocation appeal and there hadn't been changed circumstances. That's para 14. And then perhaps we can go to para 24-25. The first-year tribunal judge said this wasn't a second punishment. Para 24, it was a decision based on a change in the law. And the change in the law was Part 5 of the 2002 Act. And then the Court of Appeal deals with the matter. I think one can pick it up at para 34. And this is the critical principle. Lord Justice Stanley Burnton, the respondent was not entitled to disregard a determination, but of course different considerations may apply, whether as relevant fresh evidence that wasn't available at the date of the hearing, or a change in the law. And then between 35 and 37, similar principles are set out, and then at 38, the conclusion is that changes in the law entitled the respondent to review the appellant's position and form a view whether his circumstances fell within the new law and he was deportable. So it's authority that a change in the law allows the respondent to redeport a person on exactly the same facts as before, even though their deport appeal was allowed previously. So we say that this case speaks volumes about the weight and scope of a statutory deport appeal, and we say it doesn't determine, of course, the issues in this case, but it would be consistent with the logic of MA Pakistan if an appellant isn't bound by deport appeal when, to use the same language as the respondent in his written case, the legal system reverses the basis of the ruling that the decision to deport was lawful. And in this case, that's obviously what happened. Then my third point, before I finally get on to the fundamental principles, there are actually some types of situation where clearly it wouldn't undermine the statutory appeals process for a person to call into question the lawfulness of the deportation process outside the appeal machinery in false imprisonment, in a false imprisonment claim, whether or not the appeal machinery had been used. Firstly, EN Serbia itself makes clear the best course is for the lawfulness of a statutory instrument to be determined through the JR process. Even if a person appeals at the same time, his appeal might be adjourned to await the decision of the judicial review, or it might not, particularly if he's on the detained fast track. Second, the unlawfulness of the deportation decision may be latent, as occurred in one of the cases in your bundle, Gulad, volume 556. If the appellant wasn't aware of the latent defect, obviously he wouldn't have been able to raise it in the appeal process. The latent defect might be pretty run-of-the-mill, or it might be bad faith. The third point is the appellant...
Which was the case which illustrated that?
Gulad, that's at 556, where there was a latent defect, and the appeal process was gone through and it failed, and then at a certain point the Secretary of State said, we're actually withdrawing the deportation order because it was invalid. And the Court of Appeal held that it was invalid ab initio and hadn't had any effect on Mr. Gulad's leave to remain. The Secretary of State admitted that there had been a latent defect. It never quite became apparent what the latent defect was, but there it is. And then the final thing is an appellant might die before the appeal was determined or before he was able to appeal, and a relative might want to sue on behalf of his estate for false imprisonment. So we don't actually accept the premise that it would fundamentally undermine the statutory appeals scheme if someone was able to call into question the lawfulness of his detention in false imprisonment proceedings, because the statutory appeals process actually has a relatively limited function. And in particular, we say if the respondent can reopen the process, so to speak, because of a change in the law, why can't the appellant? But now I get on to the fundamental principles, because our main point is that it's wrong in principle to treat the availability of the deport appeals process as negating the fundamental right of a subject to go to court in an action for false imprisonment and to say to the court, to submit to the court, I was unlawfully imprisoned by the state without a trial, and the unlawfulness is X, Y, and Z. And now the first fundamental principle we rely on is quite a broad one, and it's that the tort of false imprisonment is an important constitutional safeguard of the liberty of the subject. If one needs any authority for that, it's Brockhill, Volume 1, Tab 14, Memory Stick 597, 43 F to G, where that is said in terms, and I don't ask the court to turn it up. Now, obviously, this is quite a broad proposition, but in our submission, it follows that the strong starting point is that in a false imprisonment action, a subject should be entitled to question all aspects of the lawfulness of his imprisonment, and that the court should scrutinise with great care and rigour any attempt by the state to stop a subject from claiming that particular aspects of the state's decision maker were unlawful. Because if the state is able to prevent the subject questioning the lawfulness of his imprisonment without trial, then obviously the effectiveness of false imprisonment as a constitutional safeguard will be undermined. I accept that this is quite a broad principle at this stage and quite a broad submission, but I do make it. The second principle, which I can also address quite speedily, is that liability in false imprisonment is strict, and that the state must prove that every imprisonment is lawful, every imprisonment without trial is lawful, and that it's lawfully justified as the law is currently known to be. And this, perhaps I should ask the court to turn up, this is Brockhill again, Volume 1, Tab 14. And it's Memory Stick 582. And it's 28, capital B. It starts at 28, capital B, and it ends at 29, capital B. The ending being that the authorities that Lord Steyne has referred to represent the traditional common law view. It points to a decision in the present case that the applicant is entitled to recover compensation on the ground of false imprisonment where the executive can no longer support the lawfulness of the detention. And in that case, as the court will be aware, at an earlier stage, the prison governor was able to prove that the detention was lawful because there were divisional court cases which he was required to comply with, making that clear. But then the law changed and the divisional court said those earlier cases were wrong. So it's that last part of this passage that I draw attention to. And I'm going to leave that there for the time being. I'll have a little bit more to say about the retrospective effect of court decisions later on. The third fundamental principle, which possibly begs a question that particularly my Lord Kitchener asked me before, but I put it forward, the third fundamental principle we say is that the state unlawfully imprisons a person if it makes an error of public law that's directly relevant to and is capable of affecting its decision to detain. However precisely this court reasons what the ratio of Lumber and Kambadzi, Lee Hirons are, we say that these are not just important cases, and that they do express, for modern times, the balance that the Supreme Court has struck, what standard of lawful decision-making is required, and what level of protection is available under the law in this jurisdiction for the
Can you repeat
subject.
the terms of your proposition, please, Mr. Nafler?
But the state unlawfully imprisons a person if it makes an error of law, an error of public law,
Yeah.
that directly bears on and is directly relevant to and is capable of affecting its decision to detain. And that's what we say that the ratio of lumber is. And I accept that my lords and my lady may come to a different conclusion about what the ratio of lumber is. I hope it's not a hugely different conclusion. But whatever the conclusion is, we say that it's not just another case. It's a case that sets out a fundamental constitutional safeguard for modern times. Yes, it's not a statute. Yes, it doesn't constrain the court to apply the same approach in different circumstances. But in my submission, it is such an important case that there should be powerful and weighty reasons to justify applying a lesser standard and a lesser protection in a case which on the face of it is covered and more than covered by that approach.
Speaking for myself, I don't think that is a bad summary of Lumba, but we may have to unpick the words directly bears on and directly relevant to, so it may not answer the case.
No. Well, you have our submission on that, and I'll wait to hear what
Indeed.
Milena Friend says.
Indeed.
We say direct means that it relates to the decision to detain and not something ancillary. I suppose there are other ways of looking at it, but I suppose our fundamental submission on that will be that you can't get more direct than a statutory instrument that categorises somebody as deportable when they're not, and when they should be protected by primary legislation, the EU Directive and the Refugee Convention. I probably can't put it any higher than that.
So wherever the boundary is, this falls well with
Absolutely, yes, that's what we do say,
well
yes.
on the wrong side of the line.
It can't get more direct, and it can't get more causative. So the fourth, and now we get into even more important territory, is that court decisions, and of course we have in mind Ian, Serbia, have retrospective effect. And here it's Brockhill again, isn't it? Volume 1, tab 14. And I just draw attention to the fact that the House of Lords reaffirmed the principle that court decisions are always retrospective. And in that case, the court decision was about the proper construction of legislation. And I'll say a little bit more about how that relates to EN Serbia in a little while, but can I just draw attention to the passages? It's Lord Steyn at Memory Stick 582, and it's 28 capital C. The Solicitor General argued that the question whether the Governor had authority to detain the respondent for an extra 59 days must be determined on the basis of the law as it then stood, because of court decisions, about Section 76 of the Criminal Justice Act. He said the Governor was obliged to obey the law, which was true. 28A, counsel for the appellant, relying on the declaratory theory of judicial decisions, the law has always been as it's now expounded, he said the legal principle ruled out any defence by the Governor of having relied on the earlier and incorrect view of the law. And then 29, and then on from there, he says, my lord, the principles of law invoked by the two sides pull in opposite directions. At H, the arguments of the applicant outweigh those of the Solicitor General, and then there's the passage between 29A to B, which I drew attention to earlier. So that's him. Lord Hope at Memory Stick 590, at 36 capital H, he refers to a submission by the amicus that an inflexible application of the declaratory theory might give rise to unfairness and injustice and might work against the principle of certainty. And Lord Hope says over the page, this isn't an appropriate case for detailed consideration of these arguments. I don't see how it can be sensibly argued that Section 67 meant one thing at the time when the governor made his calculation, and another when its meaning was determined authoritatively by the divisional court. That applies here, of course, as well. Section 72 can only have meant one thing, and it always meant what Ian Serbia said it meant. And he also goes on to say at B, if there ever was a case where the declaratory theory should be applied, it must surely be one where the liberty of the subject is in issue. And that, of course, we also rely on. Lord Hobhouse gave this issue particular consideration at Memory Stick 596 at 42G to 43C. Perhaps I can ask my lords and my lady to read through that passage. And he doesn't leave it there. He comes back to it at 45 capital C to 45 capital F, which I also draw attention to. And then at Memory Stick 601, towards the bottom of the page above G, no retrospectivity. He really comes back to this issue in almost passionate terms between the bottom of that page and 48 capital F, where he strongly emphasizes the constitutional necessity in order to protect subjects, not just liberty of the subject, but subjects, that judicial decisions are retrospective. And he embraces the potential uncertainty and disruption in the law that on occasion, inevitably will cause as the price of the common law system that he obviously cherishes.
Sorry, where are you reading now?
This is 47 capital G to 48 capital G.
Can be subject to exceptions.
So sorry, where is, can I ask my lord where my lord is?
Bottom of page 48 at H.
Yes, I'm very grateful. There is that. There is an
Qualification.
There is a qualification. I'm so sorry not to draw attention to that, and I'm extremely grateful for that to be pointed out. There is a qualification. Nonetheless, the power behind the earlier statements is there for all to see. And in EN Serbia, the court made a decision about whether delegated legislation was ultra vires primary legislation. So it was also a decision about the true meaning of the primary legislation. In principle, we say primary legislation should operate the way it was intended to operate from day one. And if this court was to treat the order as being lawful for a period of years, that would be to sustain a legal regime flat contrary to the regime that Parliament required to be in force, and flat contrary to the directive. So the fifth principle, and this also, I accept, does have exceptions to it, but it is the principle that a statutory instrument declared to be unlawful is treated as unlawful with retrospective effect. And that is particularly the case with statutory instruments rather than other kinds of public law decisions, for a reason canvassed in Boddington in Volume 1, tab 13. And it's at MS 551. And can I ask the court, please, to consider, it's really from 155F to 156E. I'm not sure this passage does contemplate any exceptions being made, but I would accept that hypothetically they can be.
Well, in what circumstances would exceptions be made?
Well, hypothetically they can be.
But what circumstances?
Well, not this case, obviously, but well, we'll look at it a little bit more at Boddington and Shoethmith very speedily. But hypothetically, it has been canvassed that where there is a second actor of some description who relies in good faith on an unlawful public act, including a statutory instrument, in certain circumstances, their actions may be treated as enduringly lawful despite the unlawful base. There are very, very few cases where that has been applied, and under the theory, one is looking to see whether that second actor had power to act on the proper construction of the scheme, irrespective of the lawfulness of the earlier decision. But I will go through that.
Well, bear in mind that you've very little time left.
Yeah. Well, what we've said is that if I overrun, my learned friend is happy with that, providing the time comes out of my reply. And if that's convenient...
Well, I'm very reluctant to sanction that.
Okay.
Do your best to finish in time, please.
Right.
We're talking about cases like Percy and Hall, aren't we?
Yes, well, if time permits, I'll certainly address Percy and Hall. But can I just make, because my time is incredibly limited...
But presumably there's a good passage into Smith which discusses all this, is there?
Yes, well, Percy, just very briefly then on Percy and Hall.
Is there a good passage into Smith which discusses all this?
Well, there's a passage in Lewis on judicial remedies, which is referred to in Bidd's case, which is in the bundle, which essentially says that it's not a case really about false imprisonment. It's a case about wrongful arrest. And what's critical about Percy and Hall is
No, sorry, I wasn't asking you to get into the facts of Percy and Hall. All I just wanted was a reference to the best passage on this second actor theory and where it takes one, because it's quite controversial.
The best...
Don't worry if it's... I'll come back.
The best passage about that is probably in Shoethmith, which I'll come to very, very shortly. In this case, the simple and short answer to the question, is it possible for exceptions to be made, is that given by Mr. Garnham QC in Draga. And you've already seen that. This is volume 1, tab 19, memory stick 785 at 65. And he refers to the possibility, he refers to the existence of this theory and says it simply cannot run in this case because the Secretary of State there's only one actor, the Secretary of State made the statutory instrument, the Secretary of State implemented the statutory instrument, he's completely to blame for everything that happened. And that's essentially our case. Now, first of all, our submission is that the second actor approach probably never applies in the detention context anyway. If you apply lumber literally, you're simply asking whether there is a public law error that bears on and is relevant to the decision to imprison. So you're not interested in first, second, or third actors, but it's simply interested in whether there's a public law error that bears on and is relevant to the decision to imprison. A second point is that this is clearly not a second actor case. It's the Secretary of State's order. Thirdly, and this comes out of everything in Boddington and everything in Brockhill, that although hypothetically around the edges, cases might arise where exceptions could be made to the retrospectivity of court decisions or the retrospectivity of the voidness of a public act. Not in the false imprisonment context. This is the one context where everything, every protection that surrounds the liberty of the subject should spring up fully armed. And as the passages that you've been taken to show, the theory of the declaratory nature of judgments, the theory of void statutory instruments being void from the start, are there to protect subjects, and in particular their liberty. So I just flag up where the Court of Appeal has got to on this, and it's highly circumspect. And I don't take the court to it because I really must finish by 3 o'clock, but it's Lord Neuberger as the Master of the Rolls in the Shoesmith case, which is in volume 2, tab 20, and it's memory stick 828, and it's 141 to 147. And it shows the extreme, I mean, he recognises that exceptions might be made in highly limited circumstances. But what he says vindicates how sketchy the theory is, how carefully it needs to be worked out on a case-by-case basis, and how unlikely it is to be applied in a case where the liberty of the subject is an issue. And as I say, fundamentally in this case, the problem for the Secretary of State is that it is his order. He made it, he implemented it, he's completely responsible and no one else for the consequences. 6, very briefly, the principle is the respondent can't rely on a tribunal decision to supply a lawful justification. The principle is, as the court knows, that a tribunal or court decision only supplies a lawful justification for imprisonment where it expressly authorises the detention of an individual for a defined period. And that's Brockhill, volume 2, tab 14, as 26C to D, 34A to C, and then pages 34 and 35. And there's lots of authority to that effect, which we've referred to in our written case. Then I come on to the most important principle, principle 7. So, sorry, just pausing there. Even if the tribunal, for example, independently decided that Mr. N had committed a particularly serious crime, which it didn't, but even if it had done, it simply wouldn't be of any assistance to the Secretary of State. It wouldn't preclude, it wouldn't be an express authority providing a lawful justification for detention because of the Brockhill principle. But I come on to the most important principle of all, which is that and this is directly addressing the reasoning in Draga, which is that the respondent can't derive lawful justification out of a statutory implication. And that's Kawaja, volume 1, tab 10, and it's memory stick 472. And it's 108 capital B to 108 capital H. And he refers between F to G to Zamir, the decision of the House of Lords that was overturned, where they made an implication based on the scheme of the Immigration Act. That's between F and G. And then 109, A to G, and he's quoting again from Zamir, Lord Wilberforce, my lords, the reason I've given, I'm of the opinion that the whole scheme of the Act is against this argument, that it's a matter for the court to decide whether somebody is an illegal entrant. And then Lord Scarman around capital D, that reasoning gave insufficient weight to the fundamental consideration that this is about the liberty of the subject. And then at G, there can't be any interference unless Parliament's unequivocally enacted to the contrary. And Lord Bridge is to the same effect at 120 F to H and 122 E to G. In my submission, Kawaja is bang on point, and it's probably the most single important reason why Draga is wrong, that it's wrong in principle to treat legislation as, by implication, cutting down fundamental rights, including the right to liberty, and including, we would say, the right to seek redress for unlawful imprisonment without trial by the state, the right to come to the court and say, I was unlawfully imprisoned because there was an unlawful order, which was the cause for my misfortune. Our written argument at core volume 65, footnote 65, as it happens, refers to more modern cases where that principle has been, the Kawaja principle has been repeated. The eighth principle is that the legal certainty principle is a very weak one and on its own has very little weight in the false imprisonment context. And I just address this because Lord Justice Sullivan added legal certainty into the mix in his judgment. The first thing I say is that the principle that the law should be certain and that there should be an end to litigation, obviously that principle exists, but it exists in stronger and weaker forms. The strongest form is where the principle hardens up into res judicata and issue estoppel. But the respondent doesn't submit that res judicata or issue estoppel apply in this context. And presumably that's because the respondent has looked into the position and looked at the case law, which indicates that these are private law, not public law principles. In general, they don't apply even by analogy in public law proceedings, because in public law proceedings, the interest is in getting to the truth. In any event, res judicata and issue estoppel are not relied on as reasons why Mr. N can't raise the unlawfulness point in false imprisonment proceedings. Another way in which legal certainty sort of hardens up into a relatively strong principle is the abuse of process principle, which I accept one does find in public law cases to some extent. But again, the respondent doesn't go so far as to submit and never has gone so far as to submit that it would be an abuse of process for the appellant to raise in false imprisonment proceedings that he was unlawfully imprisoned. So he's relying on the legal certainty principle in its weakest form, but if you can't rely on res judicata or issue estoppel or abuse of process, how can he rely on legal certainty in its weakest form? The second point we make about legal certainty is that we accept, of course, our legal system is almost entirely stable and predictable, rather like the physical universe. But, rather like the physical universe, it does have elements of instability and unpredictability built into it in the common law. And common law doesn't always evolve at a glacier-like pace. Sometimes it will be disruptive and even explosive. And the two examples of that are, one, when a court decides that previous court decisions were wrong, the new judgment almost always has retrospective effect, unravelling whatever's occurred in the meantime. And the other example is where a court decides that a public law act, including a statutory instrument, is unlawful. Again, almost invariably, it's treated as void from the start with the same disruptive effect. So my point here is that it's well established that in particular circumstances, the legal certainty principle is displaced in the public interest for reasons of principle, essentially to protect the public. And Lord Hobhouse is really quite passionate about that in
Brockhill.
Brockhill,
Yeah.
as you've seen. And third, the extent to which, if at all, the legal certainty principle can have any traction ultimately depends on the terms of the legislation. And here I return to Kawaja. The Kawaja principle requires one to construe the legislation so as not to prevent Mr. N submitting that his detention was unlawful in a false imprisonment action. For the same reason that the appeal scheme doesn't implicitly gag him and prevent him from saying that, for the same reason, statutory construction, the legal certainty principle, as I say, in its most anodyne form, clearly can't. And you've already seen what Lord Stay, Lord Hope and Lord Hobhouse say about the legal certainty principle in Brockhill, and it took very much a second place to the need to protect the liberty of the individual, the subject. The ninth fundamental proposition is that administrative inconvenience...
What was 8?
I'm so sorry.
Legal certainty very weak.
then
It exists in stronger or weaker form.
Right, thank you. Then what was 7?
What was 7?
Yeah.
It was really Kawaja bang on point.
What was your proposition number 7? I'm saying it's entirely my fault.
The respondent cannot derive
Yes.
lawful justification
Yes.
out of a statutory implication. The statute has to be clear, express and plain. So it was wrong with respect to the Court of Appeal to say it was implicit in the legislation that the appeal machinery prevented an individual from going to court and saying, I was unlawfully detained.
Thank you.
Administrative inconvenience, no weight in the false imprisonment context. I dealt with that at the opening and I promise not to deal with it again, and I'm definitely not going to deal with it again. So that's left really a short period of time. I'm really not going to make submissions about Uller, which the respondents dragged up. All I will say about Uller is that it's been consistently distinguished and criticised. It's not consistent with Lumber. It's not consistent with B, Algeria. It's wrong for all the reasons gone over by Mr. Justice J in Kamoka. And really, it's just obviously wrong to say that unlawful deportation decision can found a period of detention. And it is, the lower courts have distinguished and criticised Uller time and time again, but only this court can administer the coup de grace to Uller, which has been a long time coming, and which now, in my respectful submission, is long overdue, and this court can and should administer that coup de grace once and for all. Percy, so much can be
Who
said.
was the unfortunate court in Uller?
Lord Bingham.
No, it wasn't Lord Bingham.
No, was it
Absolutely,
not?
it was not. It was Lord Justice Kennedy who delivered the mail.
Oh, yes, in the Court of Appeal.
Kennedy and Millett.
And it's Kamoka. Mr. Justice J was counsel for the Secretary of State in Kamoka, and he eviscerates the decision. And
Give us the reference to Kamoka.
Kamoka is volume 5, tab 59. And I'm going to crack on Percy. But he eviscerates Uller and I had to put this, but he expresses a lack of comfort about the submissions that he's said to have made that may have resulted in the Ullah decision. So Komoko is probably the one to read if one wants to look at a case. One of the many cases that have criticised Ullah, Komoko is the one. To Percy and Hall, just very quickly, there are so many things to say about Percy and Hall, and I'm just going to flag them up, say speedily, really so my learned friend knows what I'm saying before I sit down, because it's obviously a case that he's going to be rely on. Obviously, everything was obiter that the respondent will want to rely on. First, in that case, the police constables had available to them the common law defence of lawful justification for an arrest. They reasonably believed there'd been an arrestable offence. That is simply not open to the respondent. Second, Percy was actually treated in substance as being a wrongful arrest case. You don't get any consideration of false imprisonment principles there. Third, the constables were, as Lord Justice Simon Brown emphasised repeatedly, completely innocent, to use his words, but in this case, obviously, the respondent's completely responsible for the whole sequence of events. Fourth, in Percy, the police constables were true second actors. I'm not accepting that the second actor principle applies in false imprisonment, but if it does, they were true second actors. That's not the case here. Fifth, in Percy, the constables were under a duty to arrest the protesters. By contrast here, the Secretary of State under Schedule 3 had a discretion. Six, interestingly, Simon Brown LJ, with whom Sir Peter Gibson agreed, and I think Lord Justice Sheeman, who delivered the concurrent judgment, took the view that the claimant protesters ought to have a remedy. They ought to be able to get damages, but they thought that the only remedy could be against the Secretary of State, and because of the statutory scheme, that was probably not possible to do. But applying their approach to this case, that would suit Mr. N very well, because the Court of Appeal in that case clearly would agree that he should have a remedy, because they thought the protesters in that case should have a remedy. It was just a question of being able to bring the person responsible into court, which we are able to do. And finally, which I think I have time for, look at the problem with the bylaws in Percy and Hall, is you know that in law, bylaws are unlawful unless they're sufficiently clear. And there's some debate, and there was some debate in Percy and Hall about what that means, how clear is sufficiently clear. But the point is, they have to be sufficiently clear. And the argument in that case was that the map attached to the bylaws that told the protesters you can go here, but you can't go there. The argument was that that the map was insufficiently clear. It didn't really tell the protesters exactly what they weren't allowed to do. Because in fact, the court held that it was sufficiently clear. But that was the alleged unlawfulness. So that's very, very different than the unlawfulness in this case. A map attached to a bylaw that is insufficiently clear, but where the police constables are required to carry out arrests as one kettle of fish. This, as I've said, and I don't want to say it over and over again, but I just say it once more, this was a statutory instrument that contradicted a level of protection against deportation for refugees in primary legislation, in the 2004 directive, and in the Refugee Convention. It's a completely different order of unlawfulness. And as I say, for the court to give that order retrospective validity for a period of years, just to defeat a claim for false imprisonment in contradiction of primary legislation, the directive and the Refugee Convention, in my respectful submission, would be contrary to all of those fundamental principles, all 9 of them that I've tried to go over. And I do have 3 minutes, so precedent, possibly not what anybody really wants to hear about as the grand finale. But there is something the Court of Appeal said about precedent. They looked at the Wilson case, and I just put this very, very shortly. They looked at the Wilson case and said, well, it's arguable that where somebody actually is in prison, but we think a previous Court of Appeal case was wrong, we can reach a different view where somebody is actually in prison. They said it's arguable, but they didn't decide the point one way or the other. So what we simply say is at least consider deciding whether in the light of Wilson that is actually a good point, yay or nay, so we all know where we stand. What the Court of Appeal wouldn't accept was that it wasn't bound by previous authority, even in a false imprisonment context, where the person was out of prison. We say that all the reasons in Wilson why the Court of Appeal should be free in a false imprisonment context still apply, but with obviously significant less force. And I just put forward these practical matters. One, if the Court of Appeal could resolve this sort of problem for itself, that would be cheaper for the parties in the public purse. And in a false imprisonment case, it basically is the public purse that's likely to be funding both sides and the court. Two, it would relieve some burden from the Supreme Court. And three, even if the case did ultimately come to the Supreme Court, at least there would be a Court of Appeal judgment, and that would assist everyone. In this case, for example, had the Court of Appeal said, yes, there's a prima facie case that Draga was wrong, so we'll hear all of the argument and think about coming to a different view, this court would have the assistance of, a considered exploration by the Court of Appeal of the facts and the law, and that certainly would have helped me. Mr. Tam may be above all of that, but I venture to suggest it would have helped everybody for that to have occurred. So for those, I just put forward those three practical matters for consideration, and then.
Can I just say, I want to get in a question, so...
Yes, well, there's 2 minutes.
You have all your time.
Well, I have finished, I think, subject to...
No, I mean, your point about Percy Hall, I mean, I understand a lot of force, but they're really, they don't really go to the principle. And the whole, the issue of Percy and Hall and how and what Lord Brown Wilkinson said about this in Boddington, about the need to consider the effect on ultra vires bylaws in that case, what their effect is on acts carried out in the meantime, is one of the sort of unsolved mysteries of administrative law, which is why I wanted to you to refer us to the best passage. I mean, I haven't, just looking through the authorities here, there's quite a good passage in Craig in volume 566, page 2122. Don't bother to go to it now. I mean, that's just one of it. I'm sure all the textbooks have addressed this, and there doesn't appear to be a clear authority on this. So I think we've got to be a little nervous about making law, even accepting all your very strong points on the merits. So I would be grateful if by tomorrow you could just refer us to the passages which you think are most useful on this in the textbook.
Can I just respond very briefly to that straight away, that it's the respondent who's asking the court to make the law, not us.
No, I'm not arguing between you. I just want that we have to be in the position of making sure if we're making law, we know what law we're making and in what circumstances. Yeah. I just want to be referred to the relevant passages in the textbooks. So anyway, you'll be able to reply to what Mr. Tam does in due course.
Yes. You have that fundamental point that around the edges exceptions can be made. I mean, the trouble with the textbooks that one might look at is what they often don't really grasp is that ultra vires isn't just some rather inconvenient philosophical principle that happens to underpin public law. We don't really know why. As was pointed out by the House of Lords in Boddington and Rockhill, it's there as a fundamental constitutional safeguard. It's that retrospective effect of court decisions. It's that making unlawful public law acts, in particular statutory instruments, void from the start. But it's absolutely fundamental.
Yes, but I mean, that was the context in which Lord Brown Wilkinson made his remarks. And, there it is, that's what he said. And that's not unsurprisingly been picked up by the textbook writers and by subsequent cases.
But anyone who wants to create exceptions to that very, very powerful rule has a huge burden on them. And what we say
that's why I'm waiting to hear Mr. Tam attack that burden.
There's two fundamental problems with that. One, if you're going to start making exceptions, this is absolutely the last context to do it in. Two, the only clear possible exception is where there's a second actor. This is just not a second actor case. I'll come back to...
I understand all that. Are you saying you won't refer me to the relevant passages in the textbook?
Oh,
Good, well, thank you.
I will, and then I'll make those submissions about them. Of course I will, my lord. I'm so sorry. I'm so sorry to
No.
appear
Well, I
and
understand
be
all
awkward.
your
I
points,
didn't
it's just
mean
that
to
we have to look at it in a slightly
will,
different way.
Of course. Of course I will. With pleasure.
Thank you very much, Mr. Murphy.
Thank you very much.
Mr. Lee,
Nothing from me, thank you, Mark.
Mr. Tam,
May it please the court. I'm not really sure that I would agree that we are the ones who are asking the court to make the law. The Court of Appeal, we respectfully say, made the law in Draga, and it was correct. And it was correct for the reasons given. That's the nub of our case. And perhaps if I can just elaborate that slightly by saying that the problem that both Draga and this case concern is one which is obviously of great difficulty. It's exercised a lot of very clever minds over the years, and the interface, I will come to some detail on this later, but the interface between various principles has meant that there is a real problem that arises in this area. And what we say is that the common law's approach has clearly not been the approach of some other jurisdictions, which have prospective-only rulings, for example, and so on and so forth. But the common law's approach has been to look at every situation and to devise an empirical and pragmatic solution to it. And Draga is a case entirely in that mould, and the decision was quite unexceptional in that tradition. That is the nub of what we say. And if I had to identify one reason why Draga must be right, it is this, that where the error lay was, in a non-technical sense, too remote from the decision to detain, which is the key decision for the purposes of unlawful detention. This is an unusual case because, as I've just set out, it's in substance an appeal from Draga. And in this case, as my learned friend has said, the High Court never looked at the case at all. It was done by a consent order. In the Court of Appeal, the Court of Appeal did not consider either the facts or the Draga issue. And the issue that the Court of Appeal did consider is one that is really just a footnote to the argument. So it's a strange case in that sense. And the upshot of it is that in my submissions, I think I need to do the following things. I'll just outline how I'm going to approach this. The first is I'm going to say a little bit about the facts. The second, linked to that, is something about the statutory scheme and the steps that need to be taken. I apprehend, in the light of questions that were asked this morning, that the two areas may end up being blurred, but those are the first two steps. The third area of my submissions is to say something quite broadly about the overarching difficulty in public law that these cases raise. And to make good the submission that the common law has not been doctrinaire, but rather has looked for empirical solutions. And then I will come to focus on the situation in these cases, first of all looking at Lumber and more briefly at Kambadzi, about what the focus of those cases really was. And then I will identify 4 analytical routes, none of which, I should say at the outset, none of which are determinative of this case, but all of them point the same way to the what we say is the correct answer, which is the answer given in Draga. And then finally on this, I will say something about the importance of public confidence in the system and practicability. And then at the very end, if there's time, I may say a few words about the law of precedent as part of that footnote. So can I start with the facts, and in particular one critical difference between Draga and DN In Draga, it was true that the deportation action depended entirely on the 2004 order. Can I, to make that good, ask to go to the High Court decision in Draga? This is Authorities 2, tab 19, MS 768. Well, that's where it starts, but if you can actually turn over to the next page, 769, and go to, please, to paragraph 5. What we can see of the facts in Draga is that the pre-sentence report on Mr. Draga noted that if he continues to use Class A drugs, the risk of him committing further offences to support his habit remains high, but it also said that there is no evidence that Mr. Draga presents a risk of harm to the public. And his sentence, you'll see in the next paragraph, was of 18 months imprisonment. The convictions, or the offences, are set out actually at paragraph 4. If you go on to the next page, paragraph 9, you'll see the reasoning for invoking deportation there, which was to pursue the case under section 72.4. That's because of the 2004 order, because the offence has been specified as serious enough. So it appeared to depend entirely on that. If you go on to the Court of Appeal decision, which is tab 23 in the same volume, starts at MS 989, but if I can please go to 992 paragraph 17. You'll see at the, in the quotation from the tribunal determination. So this is the first tribunal's determination, so directly against deportation. The tribunal said, although the appellant has not reoffended between his release from custody and his immigration detention, we find it impossible to say that he has rebutted the presumption that his was a particularly serious crime or that he no longer constitutes a danger to the community. So it was all entirely based on that presumption created by the order and a failure to rebut it. In contrast, in DN's case, there is, we say, an independent finding by the tribunal of dangerousness. That you will get from volume 2, or part 2 of the appendix. Can I start, please, at page 165 of the appendix numbering? It's MS 302. You'll see here that this is the corresponding tribunal determination that appeals deportation. 302, MS 302 is where it starts. Can I jump into the body of the determination to paragraph 20, which is MS 311? It's page 174 of the appendix. Paragraph 20, the tribunal set out matters raised by DN, and then they say, we therefore consider whether the appellant has raised matters sufficient to rebut the presumption arising from section 72 and also the presumption arising under paragraph 364, that where a person is liable to deportation, the public interest requires deportation. And then at 21, they set out the list of offences, so not just the offence that he'd just been convicted of. The top of the next page, MS 312, referring also to cautions. And then at 22, they say that they accept that the appellant has shown a disregard for the law, has shown a propensity to engage in offences of dishonesty, and also in relation to the caution for battery in violence or threatening behaviour. The first of the convictions also indicated that the appellant was willing to assist others in circumventing the immigration laws and rules, and it is clear from the sentencing remarks of the learned recorder that she regarded the appellant's involvement in further offences of facilitating illegal entry as being in themselves serious. We agree, and it is further clear from the sentencing comments that the learned recorder found the appellant to have played a prominent role in those offences. And then at 23, they set out their conclusions. At the end of the first line, we find that the appellant has been convicted by final judgment of a particularly serious crime, and by reason of that conviction, his previous record, and potentially a propensity to engage in violence, we find that he constitutes a danger to the community of the United Kingdom. Now, pausing there, that's a whole list of things that they've put together to reach that finding. And then they refer to time of heightened security, finding attempts to circumvent immigration laws and rules in themselves to constitute a danger to the community. We therefore find that the appellant, despite his having been granted refugee status, can now be expelled pursuant to Article 33(2) of the Refugee Convention. Now, just pausing there, up to there's been no mention of the presumption created by Section 72 at all.
Well, there have been two mentions of presumption. In paragraph
yes.
20 and in paragraph 23, having considered the facts before us and the legal provisions.
Yes, I accept that they've referred to the presumption, the legal provisions, as bits of law. But if you look at the actual reasoning that they've set out there, so far they have not been relying on that. They've been
Why? They said, having considered the facts before us and the legal provisions, we find.
Well, I'm
Mr. Tam, I mean, if I can...
looking at the language they've used, and can I just make the last point, which comes from the last sentence, which is that the last sentence starts, we further find, on the evidence before us, that the appellant has failed to rebut the presumptions. So that if you read the paragraph as a whole, it does look like the earlier parts and the bulk of the paragraph is the tribunal's independent finding of danger. And then in the last sentence, they say he hasn't rebutted the presumption. And that's why we say that there is an independent finding in this case.
Could I ask a question about that? I wonder whether instead of starting at 20, you might have started at 19. The 5 lines at the bottom. The particular offence of which the appellant was convicted is one which has been so specified, and it is that provision which is relied upon by the respondent in the case of the appellant.
Yes.
So at the forefront of all this is the case specified, and so we're in subsection 4. And I think you can read most of what follows as being an examination of whether the presumption is rebutted. I do take the point about further, but how much stress you can put on that one word, I'm not sure, Mr. Tam.
Obviously, when the tribunal is necessarily considering the whole case in the context of the legal structure set up by Section 72, they are going to be mixing and matching. That's why I draw attention in particular to the way that paragraph 23 is constructed.
Well, in any event, however it's going to be interpreted, that is the tribunal's decision, it is your case that it's open to a tribunal to go beyond Section 72 and to look at the nature of the offence, to reach its own conclusion as to whether it's a...
Yes, it is, but that's something I'm going to need to address in just a couple of minutes when I come to the statutory scheme.
But you'll reconcile with that with Section 72(10, will you?
Yes, I will address that as well. That Section 72 is a way, but not the only way, of assessing whether somebody's Article 33 too dangerous.
I mean, Section 72(10 says they must begin by considering the certificate, and if they're in agreement with the presumption, end of the case.
Yes.
So what business do they go on thinking about other things?
The tribunal can always look at the facts. So what I'm trying to do is not to be hidebound by the technical approach that the statute requires, but try to look to see what the tribunal has said, which gives an indication of what they might have found had Section 72 never existed, and Article 33(2) was to be assessed without the aid of Section 72. I accept it's not a precise exercise, but things like the word further, we respectfully say, do give a real indication that the tribunal was making up its own mind and setting out its own view, and then saying, and then if you look at the legal structure, it follows that he's not rebutted the presumption.
I think we've got to address the anterior question, first of all, whether they're entitled to do that.
Well, yes, and may I do that in just a moment?
Yes, of course.
To look at the statutory scheme. I don't want this case to be entirely derailed by this point, because it is important for the purposes of disposing of this individual case, because if I'm right, it means that the 2004 order was in a sense immaterial to all of this, and the appeal will have to be dismissed in any event. But legally, which is the real interest, and I apprehend the reason why this court granted permission to appeal, the solution really ought to be one that doesn't apply only to DN. It ought to, the legal solution ought to apply to Draga as well. And so I'm not pinning the entire case on this particular point. But it is there, and we can properly say that to this court.
Well, so long as you're going to come on to subsection 10, and don't forget subsection 1.
Yes.
Subsection 1, to my mind, says this is the way in which, in the UK, we will deal with Article 33(2).
Yes.
And your submission is that it doesn't mean what it says.
Well, with respect, that's, we don't accept that, that the statute doesn't mean what it says. But what it does do is to require certain things to be done in assessing this without displacing the generality of how you would approach it. Can I deal with all these points in what I hope will be a logical order as the question has arisen? Section 72 is in Authorities 1, tab 3. I think that we were working on MS 377.
No, we weren't.
Sorry,
We were working on 383.
I'm sorry, that's my note that's gone wrong. 383. Now, the first thing to say is, of course, that Article 33(2) would stand alone if this section didn't exist. Learned Friend says it's a remarkable provision allowing for the deportation and the refoulement of a refugee. It's not actually quite as remarkable as it sounds, because if, leave aside ECHR considerations which now complicate matters, but if the Refugee Convention stood alone and you had a dangerous criminal who was removable to his home country, true it is that technically he is still a refugee at the time of the removal, but as soon as he arrives home, he ceases to be a refugee because the definition of refugee requires that he be outside his own country. So that is not actually quite as remarkable as it sounds. It does mean that if that could be carried out, he would cease to be a refugee. But the article of the convention is quite clear in what it says. I'm not going to ask to turn it up again as the court has seen it. But of course, there are lots of questions to be asked about how you would apply that in practice. And Section 72 has, we accept, made provision for the way in which that should be done. What we say it does is that in subsections 2, 3, and 4, it sets out circumstances, and 3 sets of circumstances, in which you start from a certain place in deciding the Article 33(2) question. So the section section has effect only in respect of those 3 categories of case. But the section does nothing in respect of cases that do not fall into any of those 3 categories.
Yeah, the difficulty with that, I think, is, as my Lord Wilson has pointed out, that section 72, subsection 1, contains the prefatory words, this section applies for the purpose of the construction and application of Article 33(2). And the use of the definite article, the purpose of the construction and application, would rather suggest that this is the only means by which it can be.
With respect, we say that can't be right, because there are at least 2 things that are missing from this section if it was intended to have that effect. The first is some exclusivity provision. That is to say that these, or that a person will fall within Article 33(2) if and only if he falls into one of these three categories. But that's entirely missing from the words of the section. And in fact, I think that submission really just does cover the other way of looking at it. It is the missing of an if and only if provision there.
You
So what it says
you
is,
say that it is possible to construe and apply Article 33(2) other than by reference to Section 72.
yes, I do, because it does not exclude the possibility.
Well, I think that the argument might be put against you that if that's its purpose, surely that would have been made clear. It was open to construe and apply Article 33(2) other than by Section 72. That would have been made equally clear, would it not?
Well, we respectfully say it would be unnecessary to do so because Article 33(2) is a provision of general application. And so
but this purports to say how it's going to be applied in this jurisdiction, doesn't it?
That in this jurisdiction, that there are three specified categories in which a certain approach must be taken to the question. But it does not say anything at all about the approach that is to be taken to other categories of case.
Might it be said that the word construction counts against you? It doesn't simply say construction and application. What does the word construction add there?
Well, construction is usually used as a synonym for interpretation, so it can't turn on that one word alone.
Mr. Tam, this section has been in force for 17 years. What's the authority in support of your interpretation?
Well, I'm not aware that there has been any authority either way on this particular question.
I see.
We will have a look overnight, and if there is an answer, we'll provide it. But as far as I'm aware, this question hasn't itself arisen.
This is a difficult question to answer on the hoof. It's subsection 9. It's telling you when subsection 10 applies.
Yes.
So maybe thinking that there might be situations in which you have an appeal and subsection 10 doesn't apply. So I'm interested in what those situations might be. So the appeal is under section 82 and other things.
Yes, that's essentially just that there is an appeal.
Yeah, wholly or partly on the ground that to remove him would breach obligations under the Refugee Convention, and the Secretary of State issues a certificate that the presumptions apply. Might there be cases in which you were appealing within the terms of 9A, but no certificate? And if so, what are they? Why is that "and" there?
Well,
why is it specified?
It's specified for precisely the reason that I've already given, that Section 72 deals only with these three categories.
Well, I know, but I'm asking you to make that good by showing what other things they might be interested in 9.
Well, if the question is really what other kinds of case or in what other kinds of refugee might be regarded as particularly serious criminals, even though they don't technically fall within any of these categories. The one that immediately struck me was this. If you look at 11B1, a reference to a person who's sentenced to a period of imprisonment of at least 2 years doesn't include a reference to a person who receives a suspended sentence. Now, if you go back to 72.2, that means that if you've been convicted of a 2-year offence, if you've been convicted of an offence and you get 2 years immediate, then the presumption applies. But if for some reason unconnected with the offence, your sentence is suspended, then 72.2 does not apply. However, the focus of 33.2 is on the seriousness of the offence and the danger that is posed by the individual to the country. And it's not difficult to imagine cases where even if the sentence has been suspended for reasons other than reasons unconnected to the offence, the person is equally dangerous. And we say that just looking at that one example alone, one can see that there ought to be, and we say the section allows for, categories of people who do not fall within 2, 3, and 4, but who could still be regarded as 33.2 cases.
So you have to have from somewhere else a definition of a particularly serious crime.
Well, the phrase is in.
Yeah. So there's got to be some other meaning.
Well, that would
from
be
somewhere.
That would be for the tribunal to assess and apply. And what this section says is that those words in these 3 categories of case mean that you are a particularly serious criminal and a danger unless you can rebut that presumption. That's all that it does. It doesn't purport to exclude all of the other potential categories of case.
Well, you've told us you don't intend to refer to Article 33.2, but just for my own benefit, could you tell us where it appears again, please?
Yes, it's MS 412 and 413.
Thank you very much.
And one's got to remember that this is dealing with the part about people who've been convicted.
Yes.
There's also the general part about people who are a danger to the security of the country.
Yes.
That's got nothing to do with Section 72. That's a sort of separate test, isn't it?
Yes, I can't pretend that Section 72 has got anything to do with that.
So there's clearly scope for 33.2 to operate outside the boundaries of Section 72.
Yes,
that's a different test.
That must be right. But even amongst people who've been convicted, there must, to make all this make sense, be scope for 33.2 to operate, even if you don't fall within one of the subsections 2, 3, and 4.
This only matters in this case if your interpretation of the tribunal's decision is correct.
I think that's right, and the generality of my submissions really needs to go both to the DN situation
Well, I mean,
and
one could, I hope you won't mind my saying this, you've started your submissions with a controversial reading of the tribunal's judgment, followed by a controversial reading of the effect of Section 72. And perhaps you want to move to areas which you think might be less controversial.
Well, I wasn't expecting them to be this controversial when I started, but I think I've made my points on these issues, and I should probably move on to the other submissions. But before leaving the section itself, can I make what I hope is a less controversial submission, which is the way that the 2004 order works. The provision for the order is in subsections 4 and 5. 4 is that category. 5 allows the statutory instrument to be made. And the statutory instrument, as you've seen, basically is a list of offences. And once they've been specified, they have a certain legal effect. So we're talking in this case of an order, defective though it was later found to be, that was essentially legislative, secondary legislation, but legislative. This is different, and this is an important distinction to make. This was different from the decision to deport, which is a separate discretionary administrative decision by the Secretary of State. And it was made necessarily within the legal framework that then appeared to have been set out by the Act and by the 2004 order. Just as the order was eventually successfully challenged in EN Serbia by the available route, and I know there was discussion there about what the route should normally be, the deportation decision, again, has a separate route of challenge. We know that, that's the appeal to the tribunal. So that the two are not identical. And that is why we've taken pains to stress in our printed case that this is not just a question of a decision to deport followed by a decision to detain. The legal error was in the 2004 order. It is at least one step further back than that. And it's important in this case because, so far as I'm aware, neither in Draga nor in DN was there any sustained, or rather, was a decision based on any independent flaw in the decision to deport, or for that matter, in the decision to detain. It all hinged on the fact of the 2004 order being unlawful. And that is why we say that by the time, in DN's case, by the time you get to the latter part of his detention, the legal flaw, the only legal flaw that is material for the purposes of the argument, was, in a sense, perhaps 6 steps back. I'll list them. First of all, there's a 2004 order. Secondly, based on the legal structure that set up, there was a decision to deport. There was then the tribunal's substantive determination of the appeal. There was then the refusal of reconsideration. There was then the High Court's refusal of a statutory review. And then, after having gone through all those stages, the deportation order was signed. Now, I stress that because at that point, the detention power changes, and arguably, the DN is then detained under a new detention regime. And in the latter part of his detention, it is that decision to detain under paragraph 2.3 that is in effect under challenge. And that is, I think, if I've counted it right, 6 steps on from the legal error. Now, somebody might say, well, that's just an artificial technical way of counting the steps. But first of all, it's not, in substance, that's not right, because at any of those stages, the deportation process might have stopped. So the tribunal might have allowed his appeal, or there might have been a successful statutory review, or by the time of the deportation order, the Secretary of State might have discovered something new that persuaded him not to sign the order at all. So this is not just a technicality. And the second thing is that it is possible for detention to arise for the first time after a deportation order has been signed. And if that had been the case, then you could much more clearly see how many steps had been gone through from the initial erroneous and the only erroneous decision and the actual detention.
Now, your steps take one up to 31 January 2008. He was released on 29 February. So your 6 steps take one up to a detention of 29 days.
Yes, that's right.
The vast number of days of detention were prior to this.
Of course, I accept that, and that's why I say this was at the latter end of
Yes.
his detention. But conceptually,
Do we know why he was released when he was?
I don't know off the top of my head. Let's see if we can find that out.
It was well before the
Oh yes,
regulations were found.
well before EN Serbia was decided, and it may be that there were enough legal issues arising that it was thought that he couldn't lawfully be kept in detention for a long time. I don't know. We'll look for the exact reason. But even at the earlier stages, there is the right at the beginning. There is, as I've said, at least 2 removes. And then every time the deportation action has in effect been approved by the judiciary, the number of steps gets larger and larger. So this is not a technicality. This is a very real issue. It shows how remote, to use the word non-technically, the legal error was from the detention. I should say at this point that Learned Friend suggested that we accepted that the decision to deport was unlawful. Can I make clear that we don't accept that? I think the argument is that the decision to deport was unlawful because of its reliance on the 2004 order in making it. Can I say what I do accept? I accept that once the 2004 order was held to be unlawful, it would have been wrong for the Secretary of State to proceed with deportation nonetheless. I think that probably carries the implication that if we'd carried on trying to deport on the original basis, that would have become unlawful. And we also accept that if the 2004 order had been found to be unlawful before the tribunal had decided the appeal, the tribunal could have properly decided that because the 2004 order was inoperative, it might have decided the appeal differently. And if it had decided the appeal differently again, we would have had to have ceased the deportation action. But I don't accept as a bold proposition that the decision to deport was necessarily unlawful.
Can you just help us as to why you don't accept that?
It's actually for precisely the same reason as the main issue in this case, because at the time, the decision to detain was made on the basis of the law as it appeared to be at the time. And if for some reason we had to have an argument about whether the decision to deport was lawful or unlawful, we'd have much the same arguments as we're having here. And I don't think it would be right for me just to agree that that decision to deport was necessarily unlawful.
Well, if the decision to deport had been taken in purported compliance with Section 72, and it was subsequently held after the decision was taken that relying exclusively on Section 72, the deportation must be deemed unlawful, how could it be said that the decision was lawful until that proclamation by the court was made?
Well, it may depend on the point in time at which you're asking that question, or by reference to which you're asking that question. And the reason I say it's much the same issue as arises in our case is because what we say is the solution to the problem is that which the Court of Appeal arrived at in Draga, which is that if you're trying to decide whether the decision to detain is lawful, you have to look at it as things stood at the time.
No, but I'm not talking about the decision to detain at the moment. I'm talking about the decision, the deportation order.
Well, if we had to look at that question, then much the same argument would arise. It doesn't arise because, in fact, there was a statutory right of appeal, and the tribunal looked at it, and the tribunal then upheld that, and in a sense that things moved on from there. But if it were the case that every subsequent step that mentioned the 2000 that depended on the 2004 order was unlawful, it would also mean that the tribunal's determination was not only wrong but unlawful, and all of the subsequent steps were necessarily unlawful, and you'd have this domino effect all the way through.
So you say that the deportation order was saved from a condition of unlawfulness because of the existence of an appeal to the tribunal.
Yes, again, if that question were to arise, then we would.
Let's just test that. Let us suppose that the unlawfulness had been detected before any right to appeal was exercised, would the deportation order be void ab initio?
I don't accept that.
I'm just asking, I'm not putting that to you.
Well, we would say no, because it was made in accordance with the law as it was at the time.
I see.
What does happen is that the Secretary of State is almost certainly, I think, under a duty to withdraw that and not to pursue the deportation any further.
Oh, I appreciate that. But so your argument must be, therefore, that the declaration that it was unlawful does not have any retrospective effect.
No, that's not right, with respect. The declaration is about the lawfulness of the 2004 order.
Yes.
I accept that once it has been declared to be unlawful, the order must be regarded as always having been unlawful.
The deportation order?
No.
No,
The 2004 order.
Well,
But the whole point of this is that it does not necessarily infect and undermine every subsequent step that was taken. And it's as good, the argument is, or the principle is as good for the decision to deport as it is for the decision to detain. Now, you might get different answers, and if we were to argue it out, I might be found to be wrong, and the court may say, well, the decision to deport must be regarded as always having been unlawful. I accept that possibility, but that's why I say that it...
well, I don't want to take up unnecessary time on this, but at the moment I have some difficulty in understanding how a decision that is founded upon the 2004 order, which is subsequently declared to have been unlawful and of no effect, how that decision taken under it could be said to be valid.
Well, I think all I can do is to repeat, as a matter of principle, to repeat that argument. It doesn't necessarily invalidate everything that has been done in consequence on it.
Right.
But I accept it is closer to the problematic legislation. And that's why I accept the possibility that the answer may be different.
Yeah.
But in principle, the same problem arises.
Okay.
Can I then move on to the... just check that I have dealt with all of the legal points. Yes. Can I then move on to the broad submissions about the difficulty, the public law difficulty, which has been recognised and which my Lord Care's question has actually just illuminated, that this is precisely the difficulty that public law has found with this situation. Now, first of all, I should say that as the court will have seen, that quite a lot of things are not in dispute in this case. There's a lot of tub thumping in these unlawful detention cases about high principle, but actually a lot of things are just not in dispute in this case. So, for example, the importance of liberty and the care with which the court will look at questions of detention, the basic principle that all imprisonment is prima facie unlawful and the person doing the detaining has to justify it. And even now after Lumber, the established principle that a public law error can undermine a decision to detain, so that detention authority is no longer lawful justification. So all of these things are they're not in dispute, and the actual area of dispute and of interest is a much narrower one than that. Can I say, to make this clear, that one of the things that is also not in dispute is the proposition that court decisions are generally retrospective. So, and that is why I was able to say in answer to my Lord Kerr a moment ago, that once EN Serbia had been decided, we accept that the 2004 order has to be regarded as always having been unlawful. And that is the way the English common law approaches this. But the problem for us is that none of these things actually solves the problem which the court has to face in this case. It simply actually identifies the difficulty that is involved. This problem is one which has been regarded as of particular difficulty in public law. And the essence of the difficulty really stems from a combination of two things. It's worth just identifying them, even though they're quite familiar. The first is the decision in Annis Minnick. Just for your note, I'm not going to turn it up now, is Authorities 3 tab 35, MS 1236. It is generally understood, and I use those words advisedly, it's generally understood as having abolished the distinction between different kinds of nullity and establishing that there was only one category of nullity, which is void or ultra vires. And if you need passages from that, there's Lord Reed at page 169G to 171E.
We went through all this at some length in Privacy International.
Yes, yes. And I'm not going to ask the court to turn.
No, I mean, the proposition derives not from Annis Minnick, but the way it was interpreted by Lord Diplock, and as something accepted in Boddington and in Lumber. I mean, that's right. And that's stated in that proposition of Lord Dyson. That's no difficulty there. But there's some suggestion that it may not apply with all its rigour when one's dealing with things like false imprisonment. Lord Walker. So there we are.
Yes, well, I'll come on to that, because when Lord Walker mentions that in Lumber, it's not actually necessarily confined to false imprisonment cases.
No, and that's what I said in Privacy.
There is a general problem. But that's the sort of first half of where the problem comes from. The other half of the problem is the principle which is set out in Hoffman-La Roche. This is Authorities 3 tab 36, that's MS 1313. And it's Lord Diplock's speech at page 365 E to G, which you find on MS 1383. And it's the, actually perhaps it will be worth just turning this up because there is one particular word that is possibly the word that causes a difficulty. So it's page MS 1383, Authorities 3 tab 36. He starts the paragraph at letter E by saying that the courts don't act on their own initiative, and then refers to the presumption of validity. And then halfway between F and G, he says it would, however, be inconsistent with the doctrine of ultra vires as it has been developed in English law if the judgment of a court in proceedings properly constituted that a statutory instrument was ultra vires were to have any lesser consequence in law than to render the instrument incapable of ever having had any legal effect. So it's that word ever that in a sense causes a difficulty, because it rewrites history, and retrospectively rewrites history. I can't quibble with retrospectively, because that is now an established part of the English law approach. But it does cause difficulty, because in the interim, as courts have said, people will have ordered their lives on the basis of the law as it appeared to have been at the time, rather than how it was subsequently declared by the court. It also follows from what Lord Diplock says, that until somebody with locus and the relevant enthusiasm takes action and gets the necessary declaration or quashing order from the court, then the law is presumed to be that which it appears to be, and has to be complied with, and courts don't act on their own volition. And so it's that element of rewriting history that causes a difficulty when you're trying to later, retrospectively, to judge the lawfulness of things that happened in the interim. It's actually illustrated by the chronology in these cases, in Draga and Dien. Can I just give you some dates? The 2004 order was made on the 12th, or came into force on the 12th of August 2004. Don't need to turn it up, but you'll get this from Authorities 1 tab 4, MS 390.
You set this out in your submissions at page 89.
Yes, we do. The real point is it was almost 5 years later that EN Serbia was decided. That's A2 tab 18 MS 723. So you've got a 5-year period in which the Secretary of State and the tribunal were making decisions to deport and, in the Secretary of State's case, to detain, on the basis that the statutory instrument was presumed to, was valid as it was presumed to be. Many claimants will actually have taken the same view. If they hadn't spotted the problem or they didn't want to challenge it, they might well have ordered their lives and made decisions on the basis that the statutory instrument was valid as it was presumed to be. That's where the difficulty arises. It's also worth noting that in these cases, neither Draga nor DN took action on the basis of the arguments on the 2004 order until much later in the chronology. So dealing with DN first, you see from, I'll just give you the MS number, MS 2128, that the decision to deport and the initial detention was back in July 2007. And when he appealed to the tribunal, there was no issue raised about the validity of the 2004 order. And even when he took judicial review proceedings, which are the proceedings that we now have here today, they were started on the 4th of August 2008. So it was not only a long time after the SI came into force, after the 2004 order came into force, it was also a long time after it first applied to him, because it had applied to him from as early as July 2007. It was some 9 months later. If he had then taken judicial review proceedings to challenge the 2004 order, even on the War Boys principle, as we now know, somebody would have said, well, you're at least 6 months too late for that. This is 9 months outside the time, and you've got a 3-month time limit to do it. As it happens, if you look at the judicial review claim form, which is at MS 208, it's Appendix Part 1, page 73. Actually, the 2004 order wasn't challenged at that stage. It was brought in at a much later stage after EN Serbia had been decided. So there's a long gap before even DN challenged the order. There's a similar chronology in Draga. I'll just give you the dates of this. He was detained on the 2nd of August 2006. You get that from MS 770. It's paragraph 11 of the High Court decision in Draga. But he didn't bring a judicial review at all until the 24th of June 2008. So that's 22 months after he was first detained. And again, even then, I don't think that the 2004 order was being directly attacked. So this case rather illustrates some of the quite unsatisfactory results that can flow from a strict application of doctrine. Because what the doctrine would say, as Malone and Friends' case is, well, it doesn't matter how long it takes. 5 years later, well, all 5 years' worth of decisions made in good faith on the basis of presumably valid legislation are all swept away because of the unlawfulness. And we respectfully say that that's pretty dramatic consequence of doctrine.
You haven't looked at the case of Kader, have you? Where
No, we've not cited that, and I don't think we've included that in the bundles.
you may not remember the case. It was a case in which it was found that a certain provision in Scottish law was contrary to the European Convention on Human Rights. And the question was whether that should have retrospective effect in relation to all of the decisions which had been taken on the assumption that it wasn't incompatible. And we, at least Lord Hope, fashioned an outcome which may not be relevant to this case, but it might be worth having a quick look at it.
Lord, we will do that overnight.
Cadder, C-A-D-D-E-R.
I'm grateful, and we'll have a look at that.
Yeah.
And can I just perhaps give, in the few minutes I've got left, give one example of what would clearly be regarded as an unsatisfactory result from the strict application of doctrine. It's not directly to do with detention, but the case is, I don't think I need to turn it up because I can give you the facts of it without doing that, but the case is TN Vietnam. It's in Authorities 5, tab 55 at MS 1844. And it's a relatively recent decision of the Court of Appeal about fast-track rules and disposal of fast-track appeals. The court may recall that a later edition of fast-track rules was ruled by the Court of Appeal to have been invalid, and they were quashed. And then an issue arose as to whether or not an earlier edition of the rules was similarly ultra vires. And those rules had been in place from 2005 to 2014. So almost a decade's worth of fast-track litigation had been dealt with under those rules. And the claimant's argument was quite straightforward on a basis of doctrine. They said we were in the fast-track. We had appeals that were dealt with very quickly through fast-track rules. The fast-track rules were ultra vires, therefore, they said, all our appeal determinations dismissing our appeals were a nullity and must be set aside. The actual decision of both the High Court and the Court of Appeal was that the jurisdiction of the tribunal to determine the appeals didn't depend on the rules. So that's something which I'll come back to later. But the point of raising this as an illustration was a point which was made and accepted by the Court of Appeal, that if the claimant's doctrinaire approach had been correct, and that the nullity of the rules meant that the tribunal determinations were a nullity, that had to apply to everybody whose appeals had been allowed by the tribunal. The tribunal had said, yes, we accept your asylum claim. Those were also nullities. It's paragraph 89, so I'll just give you the reference. Paragraph 89, MS 1861. And of course, if the tribunal determination was a nullity, then there'd be arguments about whether any subsequent steps, such as a granting of refugee status or granting of leave to remain, were a nullity because they were founded on that. This is the whole domino effect that happens if you apply a strict doctrinaire approach to this field. And I think in the 60 seconds I've got left this afternoon, perhaps I should just say this, as I mentioned before. The truth is, the common law has not been doctrinaire about these problems. Although we have our own rules, which are different from the rules in other jurisdictions, what the common law has done is to apply that great strength of pragmatism, the other great strength of flexibility, especially flexibility in public law, to fashion solutions for individual situations which work. And not only work, but in fact are generally pretty easy to predict, probably because they work and they're practicable. If that's a convenient moment, I can then start again tomorrow morning by showing you exactly what the common law has been doing.
Just before you do that, am I taking away the message correctly that this the Court of Appeal here decided the correct approach is to assess whether or not there has been unfairness in each case? Procedural.
In TN Vietnam.
Yes,
Yes.
procedural unfairness in each case.
Well, on the specific point that I mentioned, the Court of Appeal approved the decision that because the tribunal has jurisdiction, even in the narrow sense, to decide the appeal anyway, that doesn't depend on whether or not there are any rules. The determinations don't necessarily fall. You have to show unfairness in the individual case before you can challenge the decision.
Thank you very much. We'll sit again tomorrow at 10:30.